as I understand the draft proposed rules, they're intended to meet the criticism that chief judges have been too reluctant to identify complaints and to appoint special committees.
Excellent. So let's go back.
Your problem is that you think the chief circuit judge shouldn't be the one doing this.
That is one of the...
Yeah, but that's really beyond the scope of this hearing.
No,
that's in the statute.
No, Judge Winter, I would like again to go back to the evidence because whatever comments I may make, they may be irrelevant. I want to...
the evidence is not only in your document, the evidence is in the Breyer report too. And I take it the conclusion you're drawing, it's not an illegitimate conclusion that this should not be a self-regulatory process, that it shouldn't be done through the judiciary itself. I think that's a feeling that you share with others. All I'm saying is that you're really not commenting on the rules. You're making comments suggesting that the statute itself ought to be amended, and my committee has no jurisdiction whatsoever to do anything like that.
Well, for one thing, your committee could examine the evidence that is available and state whether applying the rules as they are drafted now would change in any way the situation that we have right now. You indicated whether the chief circuit judge should be one identifying complaints. Well, look what happens when they do identify complaints. On page 3, on the first graph, you see that for 9 years, circuit chief judges had identified only 5 complaints. Then, all of a sudden, in 2006, they identified 88 complaints. That is incredible. Now, what happened with those 88 complaints? Absolutely nothing. They were dismissed the same way all other complaints were dismissed. You can see also something that is statistically impossible. For 9 years, the number of complaints filed by complainants hovered...
I'll ask you once again, what is it that you want the rules to do to remedy your perception of something going wrong?
I will address that question because I think it's a fair question. I would like to simply to finish with this analysis of the statistics because
you've had almost 20 minutes. I'll give you another 5 minutes, but you certainly have to get to the rules and tell me something, tell the committee something about what rules you think ought to be drafted to implement the statute rather than attacking the statute.
Well, Judge Winter, I am not attacking the statute. I am attacking the usefulness of the rules. You began the hearing by asking whether the rules should be addressed to the chief circuit judge or to the complainant, and I am indicating that it doesn't matter. It won't change anything. Also, I would like to point out that the professor had 55 minutes to present...
You are not going to get 55 minutes, Dr. Cordero. The professor was engaged in a useful discussion of the draft proposed rules. I have yet to get any concrete suggestion from you as to how the rules ought to be redrafted.
The rules should be redrafted in such a way that complaints are made public, that the secrecy protecting judges is lifted, that the public knows why is it that people are complaining so that one can establish a pattern of conduct on the part of judges, either on one judge, because there are several complaints are filed against him, or on the part of judges because they engage in coordinated judicial wrongdoing. And why would they not do that if there is no possibility that they will be disciplined? In this graph that I presented on page 3, of all the complaints that were filed during 10 years, 7,462, how many judges were disciplined? 9. 9 judges of all that. That is less than 1.1/10%. That means that however much we discuss here about the rules as they stand now, they are going to be fundamentally useless because they mirror the rules that are now in effect, and therefore they are going to have the same effect as the current rules. Based on the principle that people say that the hallmark of irrationality is to do the same thing while expecting a different result, well, that applies here. I have more specific comments against on the rules, and I would like to be able.
Well, I will ask you.
You see how many people are here? It is because the committee put the announcement of the hearing on only one single website. Even the website of the Supreme Court does not contain a notice of this hearing.
File a supplemental statement with the committee. You are welcome to do so. But thank you. That concludes your presentation.
Thank you.
Next witness is Francis C.
Hello, my name is Francis Canisia, and I'm a producer. And
I apologize for mispronouncing your name, Mr. Canisia.
That's quite all right.
I want to welcome you here today. I have I've read your statement, and it will be part of the record of these hearings. And if you'll have 10 minutes to summarize your statement, to which I will add any interruptions that I make in time for that. Go ahead.
I thank you. I'm a producer. I've taken an interest in these hearings on behalf of the American public. And since we are a trickle-up government that is supposedly represented by the people believe that they have an interest in any kind of judicial oversight process. I start with a definition of constructive fraud. And constructive fraud by Beauvier's Law Dictionary, 1856 edition, is as follows. Constructive fraud, a contract or act which not originating in evil design and contrivance to perpetuate a positive fraud or injury upon other persons, yet by its necessary tendency to deceive or mislead them, or to violate a public or private confidence, or to impair or injure public interest, is deemed equally reprehensible with positive fraud and therefore is prohibited by law. And since we only have 10 minutes, I'm going to cut out a lot of my presentation here and get to the point in relation to the Ninth Amendment of the Constitution, that the Ninth Amendment lends strong support to the view that, quote, unquote, liberty protected by the 14th Amendments, 5th and 14th Amendments from infringement by the federal government or states is not restricted to rights specifically mentioned in the first 8 amendments. It was said that this category of fundamental rights includes those fundamental liberties that are implicit in the concept of ordered liberty, such that neither liberty nor justice would exist if they were sacrificed. That was in the Palco versus Connecticut case. I'm not going to cite the numbers because there's not enough time. Please, I ask the public to refer to the actual testimony on record. These hearings on judicial conduct.
Do you have any comments on the draft rules? I mean,
absolutely. I agree with Dr. Cordero in that simply the omission of rules or the surrounding facts around concerning the rules are basis for a testimony. And if the judiciary cares to hear public comment, now I'm not a lawyer, but I can tell you what I've heard from the American public at large. So if I may continue.
Oh, you may, sure, you may continue.
Okay. These hearings on judicial conduct stem from the 1980 Judicial Act, which originally wasn't intended for, but did manage to immorally and by definition fraudulently put judges above the law. For 27 years now, those who look to this branch of government for relief have been disappointed time and time again. They have been exacerbated in many instances by judges who threaten the very lives of those who petition their courts for relief. And our own former U.S. Attorney General, John Ashcroft, condemned the judicial branch of government by characterizing this branch as organized crime. You can refer to the document on record as to his exact quote. This is just the very tip of a very large iceberg, which each day gets worse, not better. Americans simply want the Judicial Conference to do something positive, act responsibly to remedy the harsh criticisms the judiciary has weathered. The Judicial Conference may have interest that not only has John Ashcroft's opinion on such judicial crime, but other officials have as well, including but not limited to Chief Judge Edith Jones at the Fifth Circuit Court of Appeals as follows. Corruption, quote, corruption in the agencies charged with enforcing our laws not only threatens communities by allowing dangerous criminals to roam free, it also undermines the confidence of our citizens in law enforcement and the criminal justice system. The same is true with respect to judicial corruption. We must all in our own countries lead the fight to ensure integrity within our police and judicial systems. So concerning these rules today, many in the public have expressed to me on behalf of my television series In the Interest of Justice that this document in itself shows an appearance of impropriety. Canon 2 implies judges shall avoid impropriety and the appearance of impropriety in all activities. That would include judicial conference activities concerning complaints against judges. The impropriety exists when judges are judging the judges. People perceive a lack of true oversight when men are the judges of their own causes and seem to form an illegal nobility. The recommendation from the general public is that an impartial tribunal of citizens should be the judges of misconduct accused of a judicial officer. And I go on skipping some paragraphs. The legal statement, shocking to the universal sense of justice. Judges should not adjudicate hearings on complaints against a judge because it creates a quid pro quo situation where judges would tend to keep other judges off the hook for accountability. The Judicial Conference must incorporate, quote unquote, the doctrine of judicial restraint and therefore accept restrictions on conduct that might be viewed as burdensome by ordinary citizens and should do so freely and willingly. And that's out of Canon 2, as you well know. Having the gumption to produce a document as the one above shows the willingness of the Judicial Conference to forego the black letter of judicial ethics in order to maintain control over the rules and keep involvement by the public out of the process. The Constitution in Article 1, Section 9, Paragraph 3 states, no bill of attainder or ex post facto law shall be passed. The fact is that it is perceivable that the rules governing judicial conduct are, in all practical effect, a bill of attainder or ex post facto law. And what I mean by that, the Constitution does not grant the kind of secrecy that the Judicial Conference is giving its judges in the judiciary through the Judicial Conduct and Disability Act of 1980. And it does so by assigning a commission of partial parties to decide in favor of their peers. At least the appearance of that to the public. From what I gather from talking to at least just hundreds of citizens around the country. Due process rights concerning complaints against government agents must fairly be decided by an impartial jury of citizens because that is what is secured by the Constitution. And I cite some laws on the record that show reinforcement of that concept. Given that we philosophically are a trickle-up government, whereby the government is by the people, Rules 11 onward accomplish just the opposite, a nobility. Quote, sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people by whom and for whom the government exists and acts. And that's Justice Matthews of the U.S. Supreme Court in the case of Woe versus Hopkins. And my main point today, if I had to emphasize a point, is that the problem is obvious when 99% of all complaints against judges are summarily dismissed. The public perceives a 99% dismissal of all complaints as a system that is broken. The report, Implementation of Judicial Conduct and Disability Act of 1980, a report to the Chief Justice by the Breyer Commission, concluding that the system works well, is perceived as nothing more than a farce by the American public in light of such a high statistic for dismissal of complaints or ruling against complaints. The American Bar Association has shown through its polls that public confidence and trust is at an all-time low. And it's less than 30%. You have to look at the different ratings they make, but if I had to average it, it's running about 30%. So you can argue 40%, but in some areas of law, it's running at 20% confidence in the judiciary. And the Judicial Conference must note these very pertinent polls done through the American Bar Association. There's a problem with the judiciary in acknowledging its imperfections. Sooner or later, a blowback effect will occur against the judiciary for suppressing the problem of judicial misconduct. America is demanding constitutionality by all three branches of the government. The Judiciary Act of 1801, Section 31, 6th Congress, Session 2, Chapter 4, is a preemptive congressional act section that prevents the judiciary from undue rulemaking. It is a legislative act that prohibits making regulations that are repugnant to the Constitution for the public that doesn't know what that means. Provided, and the quote is in the ruling, quote unquote, provided always that they are not repugnant to the laws of the United States. The draft rules of the 1980 Act are repugnant in that they don't afford an impartial hearing concerning complaints against judges. And I'm going to cut through a lot of this again, because I know I'm feeding upon the time of this hearing.
Are you suggesting that the committee had power to provide decision makers other than judges in its rules?
Well, I think that the Judicial Conference is a very powerful agency, and that what they do,
it would require action by the Congress of the United States, would it?
Well, obviously, the act has to go through the Congress. There has to be oversight since it is a congressional act.
What you're suggesting is something that simply, you may be right, but what you're suggesting is something that would require legislation. It's totally beyond the jurisdiction of this committee.
Yes, but rulemaking should not be repugnant to the Constitution of the United States. And that's the appearance of impropriety for some of these rules is apparent to many Americans. When the rules...
I can well understand why there is doubt, why there is skepticism about a process, as there always is about any self-regulatory process. I can understand that, but these rules, this committee does not have power to depart from the statute. And the statute sets up a system that you don't like, and I think you're just in the wrong forum, that's all.
Well, I think that whatever happens with the judiciary reflects upon the judiciary committees at both the House and the Senate. And there should be some kind of crosstalk. In fact, if I may, the report, Judicial Independence, Interdependence, and Judicial Accountability, Management of the Courts from the Judge's Perspective, Institute for Court Management, Court Executive Development, a very prominent report of May 2006, just a little over a year ago. Program Phase 3 says on page 11, to answer your question, Justice Winter, a review of the separation of powers doctrine and the interbranch conflicts created will enhance the understanding of judicial independence. Separation of powers does not specifically mean creation of a barrier that positively presents any connection or contact between the branches. Preferably, it finds expression mainly in the existence of a balance among the branches, powers, in theory and in practice, that makes it possible interdependence in the context of specific reciprocal supervision. Although the judiciary is an independent, co-equal branch of government, the constitutional doctrine of separation of powers allows some overlap in the exercise of governmental functions. This overlap is sometimes referred to as the doctrine of overlapping functions. So I think that pretty much explains that the judiciary itself, by its highest judges, through this report, communicates to the world that there should be some sort of interbranch communication.
Okay, would you wind up, please?
Winding up. The American public, from my observance, wants the Judicial Conference to add to the rules the following. Complaints are too often ignored by the Judicial Conference, and it hardly ever gives notice to the movement. The citizens demand that once a complaint is filed, an index number must immediately be issued by the ruling authority, and that an official hearing must be granted within 30 days. And that would be helpful. It would actually resolve a lot of the problems that Dr. Cordera has brought up. And that's basically, I just conclude now with that the finding must address each of the specific allegations and be released publicly and put on the record. Canon 2 states, public confidence in the judiciary is eroded by irresponsible or improper conduct by judges. A judge must avoid all impropriety and appearance of impropriety. A judge must expect to be the subject of constant public scrutiny. And so that's par for the course that the public expresses its opinion through me today. And I also want to address one last point before I go that Dr. Cordero alluded to, and I would like to say that the rules are dependent on the qualifications that the Judicial Conference has set for misconduct. However, many in the public believe that breaking the law in itself is grounds for misconduct, and that there's no discretion to ignore jurisdiction, and there's many functions of a judge where discretion does not come to play, where the judge must follow the law, and time again, judges are not following the law. And what I have experienced, and what other Americans have experienced, is that the other judges rally to protect the judge who broke the law. And then it becomes a conspiracy, an ever-building conspiracy. And I have experienced this firsthand. I'm not here to talk about my case, but I tell you that I have experienced this firsthand, and it goes on and on and on. And my next step is to file some complaints with the Judicial Council, and I wonder what's going to happen. So on that note, I thank you very much.
Thank you. Thank you very much.
Thank you, Justice Winter.
That concludes the hearing.
Will you permit further testimony from the public? I requested 3.5 weeks ago to be permitted to testify. I wish to address specifically the rules.
I know of no such request.
I have it right here.
I can't entertain
email from
it
the
now.
Judicial Conference.
If you will,
the administrative office, rather.
If you listen to me, if you will, anyone who feels they asked to testify, and I would like to see the documents in which you asked to testify and to see that they were filed in a timely fashion.
I have it right here.
You can send them to me.
And I have a draft statement addressed to the rules, specifically the violations of the statute reflected in the rules with respect to merits relatedness
Comment
and
period
confidentiality.
on the rules is still open. It is open until October 15th. If you would like to comment on the rules, please do so. We welcome it. But I'm not here to get in an argument with the audience, and I'll have the room cleared if that's done.
The draft rules contravene the statute with respect to confidentiality, because the statute does not require confidentiality of anything but the special committee proceedings. And as you know, it's only a negligible percentage of
Seven special investigative committees.
in 25 years.
In 27 years.
Since 1980. Right. So actually the statute does not require confidentiality. This is something that has been broadened improperly by the federal judiciary to encapsulate the whole process and to prevent the public, Congress, from understanding what a scam the judicial complaint mechanism is as proposed in the federal judiciary. Now, that is one aspect of what I wish to point out today with respect to the draft rules. The other aspect is, as you know, all of the complaints are not only dismissed by chief judges, and then those dismissals are affirmed by the judicial councils, but the overwhelming majority of those dismissals are on grounds of merits relatedness, that they are related to the merits of a decision or procedural ruling.
She said totality.
Well, not only is it a cop-out, but you need to know. And it's been incredibly, it's been overlooked and concealed, that the statute does not require the dismissal of complaints that are arising from decisions and procedural rulings. The language of the statute is may. It gives discretion. It is the federal judiciary, by its draft rules, that now have said must. They must be dismissed. And that replicates similar language in the former and extant illustrative rules adopted by the circuits, where the language is will dismiss, no, shall dismiss, Well, the federal judiciary is making mandatory what the statute gives discretion to the judiciary to examine. Obviously, every case involves decisions, rulings, and
to the merits, that's what the prior committee acknowledged.
Right. What the federal judiciary does is make decisions and rulings in cases. It's with respect to the conduct in those cases that complainants seek review. To say that, no, they cannot be reviewed in a disciplinary context is wrong, is not correct. It's not authorized by the statute. And the important consideration always is not to be misled by the federal judiciary's claim that, complainants are whining and complaining about decisions which are erroneous and that they think are wrong. No, complainants over and again, as you know, they're not complaining about wrong decisions. They're not complaining about erroneous decisions. They're complaining about corrupt decisions. They're complaining about decisions that not only fly in the face of controlling black letter law, which, as you said, gives them no discretion at all, and they're disregarding their mandatory duty to act under rules of law, but they are falsifying the facts on which the law depends in their decisions.